have questions, please write them on the form provided to you by the bailiff. Please write your questions legibly so that I can read them. And please feel free to take some time to read your question to make sure it reads the way you want it to read. The reason I say this is that on occasion I'll receive a question from a juror, and looking at it, it might appear that a word is missing, something is not quite complete with the question. I am not permitted to complete or revise your questions, so they'll need to be presented as written. So what will happen is I'll ask the bailiff if there are any questions. If the bailiff says there are, I'm going to ask the attorneys to approach here, so we won't be watching you. And just take whatever time you need to, finish writing your question and reading it to make sure it reads the way you want it to read. And then the bailiff will collect the questions, and then I'll need to read those questions to the attorneys before the questions can be presented to a witness. So feel free to take your time, make sure if you're going to write a question, it says what you want it to say, and then I'll be able to read it. All right? Now, do not put your name or juror number on the question. Do not discuss your question with your fellow jurors. If the court does not ask the question because it is not within the rules of evidence or not relevant to that witness's testimony, it is not a reflection of any kind upon you. If a particular question cannot be asked, you must not speculate about what the answer might have been, nor hold it against either side. Now, just a few other housekeeping matters. As I mentioned last week, feel free to bring jackets, sweaters, whatever the case might be, in order to make sure that you're comfortable throughout the proceedings. It's a little bit difficult to predict what the temperature is going to be in here, and it does vary from time to time. At times it can get rather cold in here. So I want you to be comfortable during the trial. So please feel free to make sure that you bring an appropriate attire to make sure that you're comfortable. Typically recesses will be 10 minutes in length, and the lunch recesses I've already discussed with you will typically be from noon to 1:30. And often between 1 and 1:30 I'll have some other matters that I'll be hearing. Now, if at any point in time you have any problems hearing any of us or seeing anything, please just let us know and we will correct that. All you have to do is just put up your hand, let the bailiff know, and we'll get that corrected. If you would like to bring in bottled water or a cup of water into the courtroom, that's perfectly fine. I'd ask that you not bring in coffee, soft drinks, or snacks. If at any time you have any personal emergency, please just send a note to the bailiff and we'll attend to that immediately. Ladies and gentlemen of the jury, you have been sworn to try this case. You will decide all disputed issues of fact. But until the case is submitted to you with the court's instructions of law, you must not discuss this case with anyone, even among yourselves. Do not discuss the case with anyone. Do not allow anyone to discuss the case with you. Do not talk to the defendant, the lawyers, or the witnesses. As I've mentioned, do not investigate the case in any way. Do not read or listen to any news accounts that discuss this case. Please always remember that your decisions in this case must be based strictly on the evidence received during this trial and the court's instructions of law. All right, ladies and gentlemen, what we're going to be doing next is proceeding to opening statements, and I've touched upon those in my preliminary instructions. Opening statements are different from the information that was provided during the jury selection process. That was designed to give you a very brief overview of the case to see if you had read, heard, or seen anything about the case through any means whatsoever, and also to see if there might be any issues involving the case that would be of relevance to you serving as a fair and impartial juror in this case. We're now at the stage where the attorneys will be allowed to present opening statements. The purpose of an opening statement is to give you an overview of the case, to assist you in more easily following the evidence as it unfolds during the course of the trial. The prosecution, having the burden of proof, will go first, and as I've mentioned, the defense may present an opening statement at this stage of the proceedings, but is not required to do so. The defense may reserve the right to present an opening statement until later in the proceedings, or the defense can elect not to present any opening statement during the entire course of the trial. The defense is under no obligation to present an opening statement. And you must not hold it against the defense if the defense elects to reserve the right to present an opening until later in the proceedings, or not to present an opening statement. Keep in mind, as I've mentioned, and you'll hear me say this on many occasions, that the statements or remarks of the attorneys throughout the entire trial of this case are not evidence. And that includes the opening statements of the attorneys. The opening statements are simply designed to tell you from the attorney's perspective what the attorney believes the evidence will be. But the opening statements are not evidence. All right, so we're now at that stage. I'm going to be giving the attorneys the opportunity to present their opening statements.
One concern before we proceed, Your Honor. May we invoke the witness exclusionary rule?
Yes, absolutely. And in the event there are any potential witnesses present in the courtroom, I don't believe there are any, but if there are any, you cannot be in the courtroom during this trial. So if you are a potential witness in this case, you must leave the courtroom. All right, I believe everyone understands that. Does that address your concerns?
It does, Your Honor. Thank you very much.
Very good. All right, then, Mr. Rivera, you may proceed with the State of Hawaii's opening statement when you are ready to proceed.
Thank you, Your Honor. May it please the court, counsel. Down this path is horror. Down this path is the overpowering odor of the stench of death. Down this path lies Charlie Scott's jawbone, her fleshless jawbone, split into two pieces, laying 6 feet apart. Down this path lies clumps of Charlie Scott's red hair strewn about. Down this path are her fingertips and the nails of her right hand, laying alongside a body piercing with flesh still attached to it. Down this path, there's a pool of maggots, 2 waves of maggots, which feast upon Charlie's rotting flesh in order to satisfy their need to feed. Down this flesh is Charlie's mangled black bra with cuts and punctures in several places. Down this path is Charlie's long black skirt that her mother just bought for her because of her pregnancy. And that skirt had at least 20 puncture wounds concentrated right below the waistband. Down this path is Charlie's maternity blouse with blood-like stains running down the front of it. That was the outfit Charlie was wearing when she bid her two sisters farewell earlier that evening. Down this path was Charlie's favorite spring blanket covered with maggots and the source of the overpowering stench of death. Down this path is where the defendant himself had been before. And lastly, down this path is the end of Charlie's dream of becoming a mother. Before she was murdered, Charlie Scott was in a happy place in her life. She was 27 years old. She was about to become a mother for the very first time. She was in the 5th month of her pregnancy, and she was really looking forward to giving birth. She was very excited. One person who did not share that excitement was the father of her unborn child. That was the defendant, her ex-boyfriend. Charlie Scott and the defendant met sometime around 2009 when they both worked for Mono Foods in Paia. She was 3 years older than him, and they became a couple. They actually lived together for about 2 years. And although they were supposed to be a couple, they did not have a loving relationship. The defendant would tell his friends that they were just roommates, and he did not like to take pictures with her. Now, after the defendant and Charlie Scott split up, they did remain in contact with each other. And Charlie's family members will tell you that she still loved him. She still had feelings for him, even though she knew he didn't care about her. Now, about a year or so later, in September or October of 2013, defendant had another girlfriend that he had broke up with, and her name is Taylor Farner. After his breakup with Taylor Farner, she will tell you that he confessed to her and told her, "I hooked up with a, quote, bar slut, unquote, and got her pregnant." The bar slut that defendant was referring to was Charlie Scott. She became pregnant. After the defendant found out that he had impregnated Charlie Scott, he insisted that she get an abortion or that she terminate her pregnancy. And he even went with her to Planned Parenthood to make sure that she was going to go through with it. Charlie Scott, though, on her own, made the decision to become a mother. On Sunday evening, February 9th, 2014, Charlie's two sisters and her mother saw her for the very last time. She did not tell anyone where she was going to go, and she did not tell them whether she was going to meet with anyone. The next day, on Monday, Charlie Scott doesn't make any contact with her sisters or her mother. And this is very uncharacteristic of her because she had always kept in constant touch with her family members. Her mother, Kimberly Scott, went to her residence that day and found that Charlie's car was missing and one of her dogs was gone. Still no contact or nothing from Charlie Scott throughout the day. Late Monday evening, Kimberly Scott called the Maui Police Department and reported that her 5-month pregnant daughter was officially missing. Now, the police, following up on a missing persons report the next morning on Tuesday, spoke with the defendant at his home. And for the first time that Tuesday morning, they heard from the defendant his first version of how he had asked Charlie to take him out to Kenai to help him fix his newly acquired Toyota 4Runner that he claimed had broken down on the roadside. One day later, the defendant went to the Wailuku police station, and there he provided Detective Wendell Liu with 2 additional versions of his original claim. You will hear both of those versions, and you will see photographs of the defendant's hands which contained injuries. And you will hear his different versions of how he got those injuries. The only reason defendant claims he had his 5-month pregnant ex-girlfriend take him late at night to a remote area past Kenai is that his 4Runner broke down. That's the only reason he gives. Ladies and gentlemen, the testimonies of lay witnesses, police officers, defendant's mechanic, and a cell tower analyst from the FBI will testify and will prove to you that that claim is fabricated. The evidence will show that 2 cell phones went out towards the Kenai area on the night of February 9th, 2014. One returned. That was the defendant's. The one that never returned belonged to Charlie Scott. You will hear from a Maui Fire Department fire inspector, and he will describe in detail how Charlie Scott's Toyota 4Runner was intentionally set on fire using an accelerant. Her vehicle was completely incinerated. You will also hear from a forensic entomologist, and that's a person who studies insects as they relate to criminal cases. A forensic entomologist will testify and tell us that the maggots that were recovered from the area where Charlie's body parts were found will provide us, among other things, with an approximate time of death of Charlie Scott. Dr. Harl, a medical examiner, and Dr. Damerol, an orthodontist here in Maui, will also testify and will tell us how they conducted a dental comparison on the jawbone belonging to Charlie, and they will describe how they compared the dental x-rays of Charlie with those of the jawbone, and they were a match. Those are Charlie's jawbone. A forensic anthropologist, now that's a person who studies human remains as it relates to criminal cases, will also testify and tell us that she received those remains, the jawbone split in 2, among other things, and conducted a trauma analysis. She will testify that the jawbone, in addition to containing numerous fractures, showed clear marks of dismemberment, blunt force trauma, and the removal of flesh using at least one serrated edge blade. You will also hear from biologists from the Honolulu Police Department, their DNA forensic laboratory. They will explain how quickly the DNA degraded on Charlie's jawbone to the point where they could not conduct any conclusive tests on DNA of that DNA on the jawbone. They were able to conduct some tests. And what they did find was Charlie's blood on a pair of blue jeans, which was recovered 5 miles away, approximately 5 miles away from where Charlie's jawbone was located. They also confirmed that the fingertips recovered from that scene belonged to Charlie Scott. Ladies and gentlemen, the evidence will lead you down this path where you will find a verdict of guilty beyond a reasonable doubt. Down this path, the defendant is responsible for this horror.
Mr. Arpo, does the defense wish to present an opening statement at this time?
We do, Your Honor.
You may proceed.
May it please this honorable court, counsel, ladies and gentlemen of the jury. This trial is about Stephen Capobianco finally getting his day in court. A court that follows the American justice system and not the court of public opinion. Because what the evidence in this case will show is that rather than conduct any legitimate, full and fair investigation to find out the truth about Carly Scott's disappearance and death, Stephen Capobianco sits here today because everyone from Carly's family to the detectives in this case, and then even the court of public opinion, even his friends, had determined him to be guilty by the time he was arrested in this case. What the evidence in this case will be is that months before his arrest, Stephen Capobianco was being presumed guilty by the police to the exclusion of any other possible witness. More accurately, what the evidence will show in this case is as early as the day following Carly's disappearance, Stephen Capobianco was the sole and exclusive suspect of a relentless investigation to make him guilty. The evidence in this case will be that from February 12th of 2014, the only investigation conducted was one to determine Stephen as the responsible and to ignore any other possibility, no matter how concrete, no matter how substantive these other leads may have been. The evidence will show a complete lack of procedural integrity in this investigation, and a complete lack of substance to this investigation by the time Stephen was arrested for these crimes. To be clear, the evidence will show that even though investigators were informed of multiple people who could otherwise qualify as suspects in the disappearance and/or death of Carly Scott, these investigators evidently refused to seriously investigate anyone but Stephen Capobianco. Moreover, the evidence will show that by the time MPD is assuring the public, days after Carly's disappearance, that there is no serial killer emerging since the disappearance of Mo Monsalves a month before Carly disappeared, MPD had no option than to stick with Stephen as the fall guy, even though they had no evidence against him when they committed to him as the guy. In this vein, what the evidence will show in this trial is the need to find Stephen Capobianco guilty of these crimes once the investigation committed to him as the only suspect. You will hear evidence of how Kimberlyn Scott, Charlie's mother, pointed the police in the direction of Stephen simply because she hated Stephen and presumed him to be the guilty person. And how she and her family relentlessly pursued MPD to focus on Stephen. You will hear evidence how rather than an investigation which asked people, do you know anything about who did this? This was overwhelmingly an investigation focused on Stephen, with questions more like, yeah, but have you ever seen Stephen have violent outbursts when kids touch his pastries that he made over at Mama's Foods? Or, yeah, but has Stephen ever had tantrums at work? You will hear evidence of the most unusual motivations, the most unusual pressures to prove Stephen guilty by the MPD officers involved in this case. And this is not to say that Stephen is completely without fault for sitting where he is today. The evidence in this case will be, probably to a nauseating degree, that Stephen Capobianco lied to Detective Liu from the very start regarding his knowledge and or involvement with Carly's disappearance and ultimately her death. Regarding this lie, this trial will finally address why Stephen and any other reasonable person in his shoes would lie to a detective questioning you for something that is, for all you know, smaller than what you're trying to hide with the lie. Regarding this lie, the evidence will show that Stephen provided the most information that he could, in relevant part, to Detective Liu and other investigators. The evidence will show that Stephen did his best, under the circumstances, to provide Detective Liu with all that he knew about the last whereabouts of Carly, all the way to the point of placing them on the road and the area he last saw her. In irrelevant part, the evidence will show that Stephen simply refused to gratuitously incriminate both he and Carly by telling the whole truth about the night of February 9th, 2014. That evidence will be coming out in trial. Ladies and gentlemen, most of the evidence expected to be presented by the state in this trial would be addressing the big lie by Stephen Capobianco. Even though, ironically, this lie or statement would have proved helpful to the investigators if taken for informative purposes rather than for guilt purposes. The other area where I expect a lot of time and energy to be spent in this trial is evidencing that Carly Scott is dead and that she died of especially heinous means. Ladies and gentlemen, what the evidence will show in this regard is that the state has never had any idea of how Charlie Scott met her death in 2014. Indeed, what the evidence in this area will show, again, will be that the state has had a very optimistic vision of Stephen Capobianco's guilt and has never explored the most common sense explanations for Carly's ultimate condition.
If I interject, that's argumentative.
That will be evidence.
But that's argumentative.
The court will overrule this.
Finally, ladies and gentlemen, what I expect the evidence to be in this case is witness after witness testifying about Stephen Capobianco's motive, even though the evidence will show clearly that Stephen was coming around to the idea of his unborn child being born, and even his worst concern, his new girlfriend's position on the issue, had come around to a supportive one. Ladies and gentlemen, I expect that you will hear more evidence about motive in this case than anything else, even though motive is not even an element to the charges. Aside from this, I expect that you will be presented with some of the most unremarkable physical evidence one could imagine, particularly for such a serious allegation relative to the defendant being the responsible for these charges. This physical evidence will come in the form of scientific evidence, so subject to contamination and manipulation that even according to MPD's own CSI guy, it renders the whole CSI process a joke. The results of this evidence will be similarly unremarkable, to the point that the odds of Mr. Capobianco contributing to the DNA presented in this case would make you leave your car at home if applied relative to Mr. Rivera's hypothetical and jury selection about parking your car at the courthouse.
Judge, that is argument. It is improper.
The objection is sustained.
Thank you.
Ladies and gentlemen, we are eager to have this trial. We are eager for you to be the fact finders. It has been our intent to try this case before a fair and impartial jury in this courtroom rather than even try to address public opinion. We thank you for this opportunity and for your service as a juror.
All right, ladies and gentlemen, what we'll do is we'll take a 10-minute recess at this time. When we reconvene, we'll commence with the presentation of evidence. Thank you very much.
Oh, I see. I think it's...
There's a